Yes, sir. Bart Howard,
Yes.
Present.
Elizabeth Trinkler,
Present.
Elizabeth Dixon, Steve Harb,
Here.
Chip Hellman.
Here.
He is participating via teleconference. Mr. Chairman, you have a quorum.
Ma'am. Each year we need to adopt the Robert's Rules of Order and review those. Is everybody conscious of the Robert Rules of Order? Are there any questions about it? Is there any reason why we should not adopt the Robert Rules of Order? And if not, I'll entertain a motion to.
Second.
Seconded. All in favor?
Aye.
Okay.
Mr.
Agenda,
Chairman,
ma'am?
we skipped over the notice of meeting.
Say again?
I need to read the notice of meeting into the record.
Okay. Read it. Sorry.
This meeting's date, time, and location have been noticed on the Tennessee Collection Service Board's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Collection Service Board's website since December 20th, 2013. This meeting was also noticed on tn.gov's public meeting calendar.
Thank you.
You're welcome.
The agenda, we want to move to adopt the agenda, and I'm going to ask for one change to add a tab 12 to the agenda before we adopt it at the administrative report.
Mr. Howard, also removing the discussion.
Discussion from the board licensing applications as previously noted in our November 13th meeting to the bottom of the administrative report. Okay. Zeros and X's, I know that. Okay, thank you. And those additions.
Make a motion,
noted.
we
Thank you.
accept the agenda as modified.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Minutes of the November 13th meeting. Susan, thank you very much for the speech. Questions, additions, or errors in the minutes of the meeting, November 13th? If not, I'll entertain a motion to accept those.
So moved.
Moved and seconded. All in favor? Aye.
Aye.
Legal report, Mr. Whitaker.
Mr. Chairman, as the board just voted to do, that entire item is going to be moved to the bottom, and I will undertake my legal report right before the board licensing issue, so we can move to the administrative things and go ahead and get those out of the way, and then we'll go from there.
Okay, Mr. Chairman, on tab 3, you will find your current complaint comparison report. Currently, the board is closing all of its matters within 180 days, 93% of the time, which is very good. The current performance measure is set at 75%. So we're meeting that. On tab 4, you will find your budget report and your current year-to-date revenue. On tab, and then right behind that, you have your expenditures through October 31st of 2013. Next, on tab 5, letter on page 5 is requesting an opinion as to whether or not the company mentioned is required to obtain a collection service license as presented to the board during the November 13th meeting. The board voted to defer the matter as instructed and instructed staff to obtain additional information as to whether or not the company has an attorney licensed in Tennessee. The response is on page 3, and it listed 2 licensed Tennessee attorneys.
That the only issue that we had to discuss about approving them for a license?
Yes, Mr. Chairman, for that particular tab, that's all there was. It appears from their submissions that there are 2 Tennessee licensed attorneys with BPR numbers provided.
That require a vote?
Yes, Mr. Chairman, it does.
All those approving, I'd entertain a motion to approve this applicant for licensure.
Second. Moved. So moved.
Moved and
I'll second.
seconded, all in favor? Aye.
Next, on tab 6, the letter on page 3 is requesting an opinion as to whether or not the company mentioned would be required to obtain a collection service license based on its business practices. This was also deferred at the November 13th meeting.
Mr. Chairman, I apologize, but given some information just provided to me by Mr. Driver, my supervisor and chief counsel for reg boards, appears there may be additional things coming down the pike relative to this, so I'm going to request that the board defer this one more time. I'm sorry for the late notice, but I just found out about it this morning, so my apologies.
Is someone going to be put out or disappointed, upset because we're not getting to it?
It just from the tone of the letter, it does not appear so, and I've not had substantial follow-up phone calls or upset or angry emails about this so far, and I'll be happy to discuss this with Mr. Miller, who I believe is the attorney that wrote this letter and who I spoke to previously about this after the meeting and try and explain things to him in a little more detail. If I had the information sooner, I would have done it before the meeting, and this wouldn't be in here, but kind of are where we are. Yes, sir. So we'll need a motion to defer to
A
March.
motion to defer tab 6 to the next meeting.
So moved.
Moved, is there a second?
Second.
And seconded, all in favor? Aye.
Next, tab 7, the letter on page 3 asks the board to render an opinion as to whether or not the company mentioned would be required to obtain a collection service license based on its business practices.
This is the first that we've seen of this? This isn't a come over from that.
No, Mr. Chairman, if you'll note, the date of this letter of inquiry is November the 20th, which is about a week after the board's November meeting, so this will be the first time the board gets a chance to look at it.
Already worked.
It indicates that they're going to be a back office of the
Looks like extended.
extended office for.
So, as long as that's all they're really doing.
Okay. Is there a motion?
Mr. Chairman, before we vote, one more thing. In my tenure as board counsel, I've not had electronic participation so far, so just to err on the side of safety, we'll need to do all votes leading up to and including the final matter today by roll call. So everybody individually. Could you hear that, Mr. Hellman?
Yes, I got it. I heard
Okay. So since we are currently on tab 7, board can go ahead and vote by roll call on that, and then we will do a separate roll call vote to approve the prior tabs considered by the board. So that way it's just done collectively and you don't have to go back through everything individually again.
Let me direct through that process. Okay.
Glad to.
Would you read the roll call, please?
So I handed it back
No
to
motion?
Susan.
I'm sorry. Is there a motion to,
I'd move to respond that no license is required based on the facts provided.
Motion's been made and seconded that we advise tab 7 that they, under their practices that they outlined, they would not be required to have a license. Okay. All in favor? Kim, would you read the phone?
Bart Howard,
I agree.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon, Steve Harb,
Aye.
Chip Hellman.
Aye.
All right, Mr. Chairman, now let's address all of the previous tabs up through tab 6 in this administrative report. And do need a motion and a second to approve all of these by roll call vote, and then Kimberly will read the roll again.
I'll make that motion.
A motion been made and seconded that we approve by roll call the previous motions that we had approved by a verbal aye vote. And Kim, would you read the roll call, please?
Bart Howard,
Yes.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Aye.
Steve Harb,
Aye.
Chip Hellman.
Aye.
Thank you. 8 now?
Actually, this is tab 8 and tab 9. These are two separate agency applications, different locations, from the same entity. Both applications disclosed pending civil actions and the details beginning on page 8. The board is asked to review the information provided and determine if these agencies are eligible for licensure.
And Mr. Chairman, on both of these tabs, if you'll note my notes upon review of this matter. Essentially, it looks like one of these files came in and had the required disclosures attached, and per my conversation with counsel for these applicants, that was intended to apply to both of them, but apparently the copy just didn't get made and included, so it's been attached to the other file as well. The board won't need to read the regulatory disclosure summary document twice because it's identical for tab 8 and tab 9, and it does apply to both entities.
There's 28 pages.
No, sir, that's I believe, as Kimberly said, there's 10 pages. The total submission, as you can see by handwritten numbers at the bottom of the page, that was from the applicant. And so there are not 28 pages in here for the disclosure summary. I've simply taken out the disclosure summary portion and had it included with the tab. So
There's a lot to read here. Is there, do you have a summary, Chris, to give us, or where should we start?
well,
Being cautious.
I would recommend that the board members start on the page that has handwritten number 8 at the bottom. The top of the page says regulatory disclosure summary, and go from there. As you said, Mr. Chairman, there's quite a bit here. Based on my review, it appears that there are regulatory and/or civil actions pending or completed against these two entities in 17 states. Among those are various final judgments and permanent injunction, $500,000 fine to the state of California AG's office, various summary suspensions, and other cease and desist actions. I mean, pretty much the whole gamut of stuff that an applicant doesn't want to hear from a regulator is in there. But it's ultimately the board's call as to what to do about this. But this is as many regulatory actions as I've seen in reviewing these applications since I've been board counsel. So I will leave you to do with that as you will.
If we had as collectively as a board, would you like to have some time to go over these complaints and objections before?
Can I ask a question?
Sure.
Have any of their licenses been suspended or revoked?
Yes, for example, in the state of Iowa, November 2012, branch license was denied. September 2011, the Kansas State Bank Commissioner, summary order revoking supervised loan license with cease and desist order and fine. August 2009, final judgment and permanent injunction, Superior Court of the State of California. That's the $500,000 Attorney General's office fine. New Hampshire order to cease and desist. Massachusetts cease order. Florida,
That's enough.
okay.
It's,
I think I see, I don't know how we need around here, do you? Is anybody? No. Okay. Is there a motion to, decline?
Yes. Move that we decline a license to both of the applications.
Is there a second? Seconded, all in favor? Excuse me, Kim, would you call the roll, please?
Bart Howard,
Aye.
Elizabeth Trinkler,
aye.
Elizabeth Dixon, Steve Harb,
Aye.
Chip Hellman.
Aye.
Tab 9?
I think we're
There's
at tab 10.
The following agency application is being presented to the board based on the net worth deficiencies on page 13 and 14. Legal counsel contacted the applicant on behalf of the board requesting an explanation of the board for the board's consideration. The explanation received is on page 3. The board is asked to make a licensure decision in light of the applicant's explanation of its financial position.
Mr. Chairman, my only real comment about this is the gentleman who responded to Mr. Osband, his email address says Asta Funding, but that's the company who apparently did the accounting and balance sheet work for the agency in question. I'm hoping that potentially Mr. Harb can make some sense out of some of that explanation, because despite 2 phone calls and this email exchange, I don't feel as if I received the clarification I needed to suitably explain the issue regarding potential financial solvency or lack of same. To direct the board's attention to what brought up the concern, you turn to the page that is handwritten, page 11, at the bottom on the balance sheet under liabilities and equity. The very bottom entry says equity negative $97,656,392. I'm sure there is a circumstance or universe under which that could get someone a license. I haven't seen it, and the explanation that I got wasn't sufficient, but if the board members feel differently, then by all means, vote differently.
Page 13 seems to have a separate balance sheet.
Well, Mr. Harb, if you look, and again, that's page 13, the net worth entry is the same as the equity number at the bottom of page 11, the negative 97 million. So, I mean,
On their balance sheet says the same thing, Steve.
All due respect to our balance sheet, this one on page 11 is a lot easier to read.
Steve, what are
What
your
was the
thoughts?
explanation he gave you? I saw where he wrote it, but what did he say to you?
in 1 second, Mr. Harb, I'll reread his email and then. That was kind of my understanding, but it seemed like even in the best case scenario, and this again is coming from a non-accounting, non-CPA background and perspective, but if the equity number is negative 97 million, their net collections for last fiscal year are 12 million, and there are receivables of 43 million, then even if every single dollar of that was collected, you're still 42 million short, give or take some change. So that is of concern.
Looks like they may have taken this, when they bought it, they took it in at dollar for dollar value to create a loss on some other balance sheet.
Yeah, it's just a massive shelter. But the thing that I find troubling is on page 3. It's on the books at 43 million. We won't recognize any revenue until we collect the full amount. They're deferring revenue forever.
That's why that's why they booked the transaction like they did.
We had net collections of around 12 million. The company continues to make timely loan payments to the Bank of Montreal from Great Seneca Collections. Commissions and court costs to third-party services are included in net collections. Incredibly bad accounting. And they're in Canada. For some reason, I do the Bank of Montreal. I guess that's why I thought maybe they're in Canada. I don't know.
At least the paper address for the applicant is in New Jersey, and Mr. Osband's office is also in New Jersey, as I understand it.
What's your question?
Well,
Does it
your,
make sense?
Would you hire them to collect your debt? Balance sheet like that?
With the statement that they haven't picked up any revenue, period, and they had 12 million of income, I'm troubled on the trustworthiness issue. You know, item 1, who is not trustworthy? I mean, that's just not accounting policy. There's so many ways to recognize the collection. The least they should do is recognize as income the amount they collected and take amortization of the portfolio against it. I'd want more explanation than they've given. I wouldn't necessarily turn them down yet. That's just,
well,
Yeah, that's what I think too. I think obviously what they actually, they are booking it differently than what they paid for it. I mean, they clearly didn't. No, but that's what
they're booking face.
they're booking face.
Yeah, they're
and-
booking face, which is just like,
really-
really
I mean, we could
Right.
vote it
not
down,
correct.
but
Assuming it's distressed assets.
It appears, and it looks like all of this is arising out of just that one transaction. I don't know why it would be out of line to ask them for the details of that. Seems to be the issue.
What do you think of, and I don't know how legally it would do to deny them today with an explanation or approve them with proper explanation. If they want to get into business right away or get out of business right away, should we make the decision today? Or?
Seems like they're already in business.
just respectfully, if more information is needed prior to a decision, then I think that's the decision to defer this matter. And with Mr. Harb's expertise and questions, phrasing the accounting questions better than I could, he could work with me to phrase it properly to get the information that the board needs prior to making a decision. So that would be my recommendation.
Motion to table this application to the next meeting. Moved. Is there a second?
Second.
And seconded. All in favor? Sorry, Kim. Roll call.
Bart Howard,
Aye.
Elizabeth Trinkler, Elizabeth Dixon,
aye.
Steve Harb,
Aye.
Chip Hellman.
Aye.
Unanimous, sir.
And on tab 11, Mr. Harb, per my discussion with you, is it my understanding that we will defer this one more time because you've not really had the chance to look at it in as much detail as you would like?
One little question.
You may, and I'll do my best.
The only section that applies to the form of the balance sheet is 622106. Is that correct? And I looked in my little book that you all nicely had there for us. And it says it shall be submitted on a form prescribed by the board and accompanied by a current financial prepared by a licensed public accountant.
Yes, sir, that's subsection
So
2.
we have to have a form, but there's no form other than the one we've had for forever that is the form. So we can prescribe the form.
I think that's what the plain language of the statute says, so if the board feels that there are changes needed that comport with the intent of the statute, but don't expand the scope beyond what the board may permissibly collect in terms of information, I think that'd probably work.
I'd agree that next meeting or between now and next meeting, I'll work with you on a new form. It'll be a very simple form, but it'll require attachment of something by a licensed accountant. The only problem I have is I don't see anything where the level of the statement in our footnotes required or a compilation, or as long as it's signed by a licensed CPA, that's all you need.
Well, as you'll note in that section of 106, the actual language is prepared, so the statute doesn't appear to specify the level of review that's required. It could be compilation, audit, or something else.
Any CPA that prepares something will give you some kind of a report at whatever level. Even if they're a CPA with the company, then they give you a disclaimer report saying what they've done, and they give you their license number, and that would suffice. So, yeah, I'd be glad to table it, and between now and then, we'll work on a new form and suggest it at the next meeting. Is that okay?
Sounds great.
Does this section 106 require us to present a form to them, or can we say a financial statement properly prepared by a CPA? Or do we have to give them a form?
Well, I think you have to read both parts. The subsection language of 106 says an application shall be submitted on a form prescribed by the board, which means the board gets to prescribe the form, as Mr. Hard mentioned earlier. And then sub 2 says a current personal or corporate financial statement, and so on and so forth.
What I plan to propose is like a 5-line form on one page. Starts out with your cash, show us your trust account number, show us your regular checking account number, total, all other assets, total assets, liabilities, equity, just 3 or 4 totals, and then attach the licensed accountant's form, more detail from the form. So our form will just have 5 or 6 lines and require the attachment to show additional detail prepared by a CPA. Now, that meets all the standards. It's a form we prescribe. We can see the trust account number and that they have a trust account and what it is.
If they're required to have one.
Well, that's one of those you kind of want to have on there, because if you have a license, you ought to have a trust account. And then you require it attached. What that also does is that lets all the CPAs off the hook because they can't sign a pre-prescribed form. So they sign their own report that's attached, and we get whatever they put as their report and the attachment, but we require details, further information on the form. But we have a pre-prescribed form, and even the simplest of folks can take it from that and just put total assets, total liabilities, total equity. You can find those numbers on the accountant's form, fill that out, and then we really get a form from a CPA.
Well, Mr. Hard, we'll be glad to work on that between now and then. And if that is agreeable with the board, then motion second and then roll call.
A motion to defer tab 11 until the next meeting?
So moved.
Moved, and is there a second? And seconded. Roll call, please.
Art Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon, Steve Harb,
Aye.
Chip Hellman.
Aye.
It's unanimous, sir.
Thank you.
Okay. Finally, on tab 12, this is an application for a new collection agency. The financial statement submitted by the agency, as required, was prepared by a CPA licensed in the Philippines but not in the U.S. The board is asked to review the explanation provided by the agency on page 4 and determine whether or not the financial statement meets the requirements as stated in TCA 6220-106, Section 2.
Mr. Chairman, the reason I brought this before the board, after speaking with counsel for the applicant in this matter, as Kimberly mentioned, the financial statement was done by a Philippines licensed CPA firm. It is of some note, and board can decide what weight, if any, to give it, that the Philippines firm has a registration number of 1, like the very first one ever issued. And they are a Philippines-based global member of Ernst & Young worldwide, their overall corporate umbrella and what have you. So what I could not and did not feel comfortable determining independently of the board's counsel is whether that satisfied the requirements of the statute section that Kimberly set forth. The other piece of information I found out that the board may wish to consider, after speaking with Mark Crocker, the CPA and Executive Director for the Accountancy Board for the state of Tennessee, he did advise that the Philippines is one of a number of countries that does not have a formalized reciprocity agreement for accounting purposes. I can't begin to tell you all of what that means, and Steve would probably understand it better, but that is the information that was passed along to me, so I'm passing it along to the board members. And with that, if the board would like to read the letter submitted and then discuss and vote as appropriate.
On page 5, it indicates that this was prepared with the accounting principles generally accepted in the United States of America. Does that give you, and the fact that they're a member of the Ernst & Young, does that give you
Mr. Chairman, please speak into the microphone.
does that give you an idea of their qualifications, Steve?
Yes. Yeah, there's substantial qualifications. And the fact that they've used Ernst & Young on their letterhead is either bold, foolish, or appropriate. But the thing that troubles me is I don't see CPA next to a signature anywhere. The opinion letter states the firm person signed it. Maybe those initials at the end of the signature are CPA, but they don't look like it.
What page are you on?
It's 8.
8.
And Steve, if you look at the top of page 7, I know it's in really tiny print, but in the letterhead section below the contact information, there's a couple line items that says BOA PRC reg number 0001, which is, as I mentioned earlier, the firm's Philippine registration number.
Board of Accountancy practice regulation number, maybe, who knows? But even with that, I'm being very simplistic. These guys are very well qualified probably to do this work, but our requirement, as simple and straightforward as it is, says a CPA or a PA firm. And to be a CPA, you've got to hold yourself out as one. And I don't see where they've held themselves out as a CPA. They've held themselves out as accountants. I know that's really a stupid thing.
Could we ask them to send us a letter signed by their CPA?
It's not out of the realm of possibility, and this is, again, based on my limited accounting understanding, and Steve, chime in if I'm off here, but as I understand the practice in the states, most of the biggest of the accounting firms, at least some of the time, do not have a specific individual CPA sign off on something like, you got your PricewaterhouseCoopers or Ernst & Young or whoever, and they're doing some giant audit for, a 9 or
We'll sign it
higher.
in the name of the firm, but it doesn't look like. Is that signature? SVG and Co. Ernst & Young is on page 8. Is that what that signature is?
That's what that signature is. And then taken in conjunction with the BOA PRC number that I referenced on page 7, these folks appear, by all indications, to be putting their stamp of approval and their opinion and, I guess, professional reputation and licensure on the line in support of their report, which,
Given the level of reports I've seen prepared by PAs in Tennessee, they're no longer there. I mean, this is a much higher quality report. We don't know the amount of work that went to do it, but you can't write that many notes without doing something.
if I may make a suggestion, Mr.
It
Harbin.
meets our tests.
The board may well wish to go ahead and approve this one, but not, just make clear that it can and will consider such submissions on a case-by-case basis and not so much that, just because of the circumstances here, that anything remotely similar that comes down the pike is going to be automatically approved. If there's a question, the board always retains the right to look at these things and review them as necessary to determine compliance with statute.
Did they fill out our form?
Yeah.
Page is our form on.
Page 9. No, sorry.
That's their form. That's their balance sheet.
No, I don't think they do.
No, they never filled out our form. I don't see our form yet. Nope. They didn't use our form.
1 second, Steve. I think if memory serves, is this
Initial application.
initial application? So
It doesn't have a form in it. It's only the yeah. Then given that it doesn't have our form in it, this is pretty good. I'd certainly make a motion to approve it based on this.
I was just going to add that I think that the information the board seeks on its balance sheet form is included here and then some by a lot. So I don't think that the board is short of any information it might need to consider
There
about their
motion made
financial
to approve
position.
this. A motion's been made to approve. Is there a second?
Second.
And seconded. All in, Kim, would you call the roll, please?
Yes, sir. Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Aye.
Steve Harb,
Aye.
Chip Hellman.
Aye.
Unanimous, sir.
Thank you, ma'am. Okay, we're out of tabs.
Yes, sir. That is the end of the administrative report.
And
I will turn it over to Chris.
Mr. Chairman, at this time, we will go ahead and do the legal report, and we will get to the actual complaint report itself in just a moment. Prior to that, I'd like to note for the record that Mr. Hellman is participating electronically because of weather-related issues and a flight cancellation, so it didn't appear that there was sufficient time to get a copy of the complaint report to him, so the remaining 4 members of the board will be doing the legal report and voting on it as there is still a quorum. However, Mr. Hellman will be participating fully in the final matter for consideration today as he is fully read up and received all the documents and is ready to proceed.
So are we going to take up the Rialto matter now and then do the legal report after Chip's off?
No, Mr. Chairman, it's the other way around. We're going to do the legal report first and with one preliminary matter, and then we'll take a brief recess just to get everyone ready and last-minute preparations as necessary, and then move forward on the Rialto matter. prior to me distributing the copies of the legal report, looks like I'll need to make another couple of copies of what I'm about to hand out, but two things. Number one, as the board is aware, in the last legislative session in 2013, the location manager requirement was deleted in its entirety. And it appears that the Collection Service Act was sufficiently amended to update that to remove all mention of it from the statute. However, there are still a couple of mentions in the rules themselves about it, which will need to be repealed as well, which can only be done by board action. We're not at the point yet for a notice of rulemaking hearing or anything of that nature, but I would like a motion and a vote by the board members to approve beginning the process of the rulemaking hearing to delete all references to the location manager requirement from the rules. So we can take that first and do a roll call like we've been doing.
Motion's been made and seconded, excuse me, it's not been seconded. Is there a second?
Second.
And seconded?
Question,
Yes, sir.
Yes.
is the rulemaking hearing only for that purpose, or can we consider any other rules that may need to be changed along with that rulemaking hearing?
Presuming sufficient notice, lead time, and approval up the food chain of command, there can be more than just that, and there almost certainly will be. Just that's the first and simplest thing, so I took that first to bring before the board. The second matter, I thought I'd made,
Interrupted, so I guess we should vote.
a vote would be helpful. My apologies.
Been made and seconded. A roll call, please.
Bart Howard,
Aye.
Elizabeth Trinkler, Elizabeth Dixon, Steve Harb,
Aye.
Chip Hellman.
Aye.
Okay, second preliminary issue for the legal report. Also in the most recent legislative session, not the one that just opened, there was a statute passed for something called the military applicant rule, which the legislature deemed appropriate to require all regulatory programs in the state of Tennessee to establish rules which set forth the expedited requirements, abilities, and whatnot for license renewal applications and the like for individuals serving in the armed forces. At this time, what I have is a first draft of some language that has been brought up so far, and it's not for reading and voting at this particular meeting. All I will need is a vote from the board members to review this language with an eye towards bringing feedback, questions, and the like back to me at the next board meeting in March, so that any expertise and specifics that you would like relative to the collection board specifically to be added to this language can be included in the final product. So if we can go ahead and do that vote, and then I will distribute the copies I have, email one to Mr. Hellman after the meeting, and then we'll move forward with the legal report.
Is there a motion to review, what are we going to, motion to review the report and then bring it up at the next meeting?
To review potential language for the military applicant rule.
Moved in, is there a second?
Second.
Seconded, roll call vote, please, Kim.
Bart Howard,
Aye.
Elizabeth Trinkler, Elizabeth Dixon, Steve Harb,
Aye.
Chip Hellman.
Aye.
It's unanimous, sir.
And I will distribute my hard copies. I believe Chairman Howard has one, and give one to the other three board members. Chip, I will email you this after the meeting, okay?
That's great. Thank you.
Hey, now we'll take a few minutes to go over the legal report. I have that.
Mr. Chairman, just for your review, and while nobody needs to stop reading, you have in front of you the legal report for this meeting for January 2014. There are 20 items listed for the board's consideration, and as always, I'm happy to take any questions once the board members have had a chance to review all the items, and then we'll vote as written or as amended at the conclusion.
Each had an opportunity to read the 20 complaints that we had. Are there any discussions about any of these specific complaints of the board members? I noticed that there were 3 that I counted of of a complaint coming in and the respondent saying the complaint was that the account had been paid in full. And on 3 occasions, the respondent says, "Oh, yes, it was paid in full." Is that inordinate amount of times that the collection agency made a mistake that the account actually had been paid in full? Do you hear that a lot?
Well, it's first time for everything, and in this case, that appears to be what happened. As I understand it, you're looking at items number 8, 9, and 10. If you'll note, the descriptions are identical because it is the same person, the same complainant, but 3 different agencies, and it appears that the problem here was with the original creditor, not any of the agencies, because as I understand it from speaking to the respondents, they were told that because most of what is done in terms of referral of accounts these days is done electronically by computer, and it was supposed to have only been referred out to one agency, but somehow a wrong button got pushed somewhere and it went to more than one. And so the complainant's attorney wrote him a very nice letter. It was a good letter. And basically said, hey, look, here's the deal, here's the law, here's the proof. You need to stop doing this or you're going to have some problems. And to each of the agencies' credit, not only did they do that, but 2 of them specifically reached back out to their client and said, hey, look, I know this was kind of an issue here, but just to make sure that this lady's not inconvenienced again, you need to do something in your system to note that this doesn't need to be sold, transferred, or rerouted to another agency inadvertently or otherwise. If it is, then that's a problem. And so it looks like the complainant and her counsel were satisfied with the outcome of this because what they asked to be done was done, and the agencies did what they could do and then went above and beyond to get back with their creditor client to make sure that this lady would not be dealing with this again 90 days from now.
It seems like an awful lot of agencies closed. Do we keep any stats on how many agencies close in a year? Are there more agencies closing and relinquishing their licenses than usual?
I don't personally keep those statistics, Steve, and that would be a Susan and or Kimberly question as to whether there's some kind of report that could be run to determine the numbers of license surrenders.
Have you noticed a bunch of them relinquishing licenses in the last year?
Actually seen an increase in agencies applying.
That's because of the
Right, the collection manager requirement being removed. We certainly can look into the system and
I was just
provide
curious.
you with that data.
Just seemed like an awful lot of them were voluntarily closing or had already closed that had licenses. So no, it's not necessary. Thanks though.
Any other questions or comments about the legal report that Chris prepared? Got to be fun writing this stuff up sometimes.
Feral monkeys, Mr. Chairman.
I'll make a motion in that we accept the legal report as prepared and presented. Second.
And a motion been made and seconded that we prepared the legal report as prepared for a roll call.
Yes, sir. Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Aye.
Steve Harb,
Aye.
Chip Hellman,
Can't vote.
Abstain.
Thank you, Chip.
Okay.
Sir, you have 4 ayes and 1 abstention.
Thank you.
At this time, Mr. Chairman, I'd ask that the board take a 5 to 10 minute recess so that we can prepare for the Rialto matter. I'll speak to the court reporter and a couple other folks, and we'll get going.
Thank you. Y'all wake up back there.
It's exciting stuff.
Ready, Susan? Okay. We'll reconvene the Collection Service Board meeting January the 8th, 2014. We'll now take up the Rialto matter that we had discussed on our November the 13th meeting. I have some written statements that I'll go in, and should you want those, then I'll give those to you. Good morning, ladies and gentlemen. My name is Bart Howard, and I'm the chairman of the Tennessee Collection Service Board. The board will now continue its consideration of the license applications for 3 affiliated and separate entities: Rialto Capital Advisors of New York, LLC, number 1570, RLBB Financial New York, number 1571, and RLBB Financial Florida, number 1572. For the purposes of this statement, these 3 entities will be referred to collectively as Rialto entities. Will each of the members of the board please identify themselves for the record? Bart Howard, Chairman, Tennessee Collection Service Board.
Elizabeth Trinkler, Vice Chairman, Tennessee Collection Service Board.
Elizabeth Dixon, member.
Steve Harb, member.
Chip Hellman, member.
The board's consideration of these applicants today is intended to serve 2 purposes: to vote on whether to grant each of the 3 Rialto entities a collection service license in the state of Tennessee, and whether to seek to assess civil penalty or other disciplinary action for alleged violation of the Tennessee Collection Service Act and/or applicable laws, rules, and regulations. Rialto entities, prior to the board's receipt of their application for licensure. At this time, I will open the floor to all members of the board for deliberation and discussion as this issue of the Rialto's entities license applications. Does anybody choose to go first, or shall I appoint? Mr. Harb? Okay, question.
Since we're voting on 3 entities, do all 3 entities have the same practices and policies and procedures?
It's my understanding that, again, these are affiliated entities, and I think as the applicants mentioned, that essentially these are single-purpose entities, the RLBB being the holding companies for the notes, and the Rialto Capital Advisors doing the work to try and make those notes perform. So, and if the board has questions specific to the applicants, I believe the applicant's counsel and a representative are here if such questions are still pending at this time. So that's up to you as to whether you'd like to address the applicants or not.
I think the fact that they're all 3 applying for a license, and because of any issues that we may have with granting one license to the other, would apply to each licensee.
That's exactly what I was struggling with, because all the stuff I read only pertained to one licensee application. I was under the assumption that the complaint was only with Rialto Capital Advisors, that there was not a filed complaint against the other 2 licensee applications. Is
Mr. Harb,
that
with respect, I don't believe that's correct. Thinking back to the objection and complaint form filed by the Race Day entity objector folks in this matter, I do believe that all 3 of the entities in question were in the caption of that document. So I believe the allegations, such as they are applicable to all 3 and should be considered as against
And
all
all
3.
the information we received applied to all 3.
Yes, sir.
Okay.
Okay. We'll have some deliberation and discussion about this matter, and I don't mind saying normally, and I've been on this board for 12 years, and we don't have this big of an issue each time. So, Harb?
The only thing that is very important to me is the pre-negotiation agreement, and it would appear that that's a consistent document that they use whenever they go to collect. It's the most important document that bothered me.
Is there any other discussion? Okay. Hearing none, I will entertain a motion to close the debate and deliberation for the license of the application at this time.
So moved.
Moved. Is there a second?
Second.
And seconded. We'll have a roll call vote. Kim?
Art Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
No.
Steve Harb,
Aye to vote closure of discussion, but not to vote on the license yet.
correct.
Aye.
We're just voting to close debate.
Yes,
Oh,
close
sorry.
debate.
Chip Hellman.
Aye.
Mr. Chairman, the vote was unanimous to close the debate.
Thank you. We are closing the debate at this time. And at this time, the board will begin the process of voting to approve or deny the application of the Rialto entities. Each board member will have a brief opportunity to explain the reasons for his or her vote. And when each board member will vote to approve or deny the Rialto entities applications. I will begin with board member Steve Harb. Yes or no on approve their application?
I would vote no. And my basis for voting no is item 2 or section 2 of 6220-107. And the issue of the pre-negotiation document and how it was presented in the opening letter to folks, that just simply goes one step beyond what I consider fair dealings and how it was presented. And for that reason, I vote no. Well, based on section 2.
Thank you. Harp. Ms. Trinkler?
I vote aye.
Trinkler votes aye. Chairman Howard?
I'm sorry, Ms. Trinkler, does your yes vote mean that you believe it appears that these entities have met the minimum standards for a collection service license set forth in Tennessee?
I do.
Thank you.
Chairman Howard, I've reviewed this, and this has been more work in the last 2 months for this collection service board, which I enjoy, by the way, than in the past 12 years. And both sides have put on absolute excellent arguments for their positions. I too have a problem with the pre-negotiation statement. I think that have I been involved in that, I probably would undo that pre-negotiation. But I feel like that they have met the strict statutes to apply them to a collection service license, and I vote aye.
And I vote no based on Tennessee Code annotated 6220-107 subsection.
Mr. Hellman, it's now to you, sir.
I vote aye. I believe they have met the minimum standards.
Mr. Chairman, at this time, we'll need a roll call vote to approve the board's position as a whole. As it appears, there are 3 votes aye, 2 votes nay in favor of granting the license applications for these 3 entities. So we'll need a motion and a second, and then a roll call vote to approve the board's position as a whole on this issue.
This is a motion to approve the board's position, not approve or disapprove of the licensure. That's already been decided. Is there a motion made for that approval?
So moved.
Motion's been made, and is there a second?
Second.
And seconded. All of those in favor will be called by the roll.
Art Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon, Steve Harb,
Abstain.
Chip Hellman.
Aye.
All right, Mr. Chairman, having voted relative to the license matter, the issue is now right before the board as to whether the board wishes to deliberate and vote on a consent order seeking disciplinary action of some kind as against these entities for the alleged or arguable legal violations that took place prior to the board's receipt of their applications for licensure. So there's deliberation and discussion about whether to entertain a consent order. This would be the appropriate time.
I think we all agree that there was some errors made by an unlicensed agency, and our statute provides for up to a $1,000 fine for each of those violations each day that those violations were committed.
And please don't take this as gospel, Mr. Chairman. This is only my opinion based on my review of the documents. As I saw in the transcript from the November 2013 meeting, it appeared that the Rialto entities, through their counsel, admitted to at least 3 arguable violations, potential unlicensed conduct. And so it appears the minimum is 3. Upon my further review of the documents, it's arguable that there are as many as 7 potential such violations from 2010 to 2012. The board is obviously not bound by that and can take that and give it what weight it does or does not wish to do so. But that's my view after looking over the documents. And so with that, I would strongly encourage the board to discuss that prior to making any decisions as to what to do with it.
Personally, the 3 are obvious to me. Does anyone else know the other?
Do we
4?
know how many accounts that these 3 companies held that were in Tennessee?
As I mentioned before, Mr. Harba, it is my understanding that the entities before us, the RLBB entities, are single-purpose holding companies, and
Didn't just buy one asset, they bought a pool of assets, probably. We can find that out.
well, that may be possible, but the only actions and conduct here before the board today are the ones that were briefed by counsel for both sides and presented in November and reviewed in the documents by the board members. And so
Documents that we reviewed, there's an opening letter that is sent to every person who has a debt. And it says, you will be contacted by us or by our representative, and paraphrasing only, to discuss how your case will be handled and assist you in managing the case. And that is very close to saying, we're going to call on you to collect the debt, since they are a third party. They used appropriately, inappropriately, however, they did use the passive exemption that was provided. So if they knew they had the passive exemption, and then they sent out an introductory letter saying, one of our people is going to call you, and in fact, one of their people did call, the employee question did call, then each time they called someone, they knowingly or unknowingly, have no issue on that, violated our law. So however many times they sent that letter, they made a contact saying, we're going to contact you in Tennessee and our representative is going to call.
I don't think that we know, we have a complaint on any other letters other than the one race day matter, as far as I know.
And Mr. Harb, if I may also chime in to your point, the contacts you mentioned, I attempted to discern as best I could distinct separate instances, whether by phone or by letter, whether email or otherwise, and that's how I came up with the number that I came up with relative to this matter. Again, not binding on the board, and the board may choose to accept that number, change it, or do something else altogether, but that's...
You just said by documents put in front of us, in that introductory letter, that was a blanket letter to anyone. It was not specifically named, I don't recall that exactly, but it was an introduction letter saying, we're going to call you. It's logical to conclude that was sent to any Tennessee debtor.
It may be and it may not be, but again, that proof is not before the board at this time, and it has not been considered, and frankly, given the scope of the objection and complaint at this point doesn't necessarily appear to be appropriate for consideration. The board may feel differently, but at the same time, this matter has proceeded for quite some time, and in order to expedite it and keep it moving down the tracks and get these folks back where they need to go in federal court as quickly as we can, respectfully suggest that we limit the board's consideration to what the board's had a chance to review. The document you mentioned, as you said correctly, is probably a form document, and it may well have been sent elsewhere, but there's nobody's name on it. We don't have proof of mailing to anybody. There's no email caption or exchange or anything like that indicating additional sendings beyond what was in the document. So I think I think the board must take it on its face, which is a form document that may or may not have been sent to anyone. It could have been and may well have been, but is there sufficient proof at this time to establish that happened? I'm not convinced, but
This board has the authority to open a complaint of its own, and that would be another matter, I think, at another time if we want to look into. As it
Mr.
is
Chairman,
now,
please
the
speak
matter-
into the microphone.
I'm sorry, the matter that we have before us now are the three alleged complaints that we're aware of, and through our attorneys has looked at some other things, and perhaps there's four things that I didn't recognize that he thinks that may also be a violation of our statute, or a contact that was made before they were licensed. Could you explain those to us, Mr. Whitaker?
In what way, Mr. Chairman?
Well, you said that you had noticed seven, and I noticed personally had noticed three. There maybe some of the other board members noticed four more, but I didn't see it.
Well, as I mentioned before, and I think I'll just stick with my prior statement, which was I classified as best I could distinct phone calls and email contacts that appeared to be primarily or solely motivated, in appearance anyway, toward collection or recovery of money on the debts in question. And so anything that didn't appear to be primarily or solely in that way was kind of dropped by the wayside. But again, I can't stress enough that this is my opinion only, and it is the board's decision. The board is charged with the authority to make this call and to do this and to determine for themselves the number of violations or not that they believe allegedly may have occurred.
Any other discussion? Chip, do you have any discussion?
No, I don't. I think I understand what Chris is saying.
I would just say, Chris, and so in your opinion, not in detail, but because I remember the three also, and I think they admitted to the three in their testimony to us. There were four other communications. We don't need to know what type or whatever, but in your thorough review of the file, which I'm sure is more thorough than ours, that you do believe that there were seven attempts to contact. You're comfortable with that?
It appears that way to me, but I also wish to stress for the record that that this is not, at this point especially, a finding or determination in any way, because whether those contacts occurred or not, even at this point, is still a matter of dispute, subject to a potential settlement offer from the board regarding those disputed allegations. And so that's, if those were to be tried and tested in order to determine their legal sufficiency, the appropriate venue for that would be a formal hearing before an administrative law judge, either sitting alone or with the board accompanying them. And we are not here, or we are not there now at that point. We are at the point of, okay, it's really a probable cause determination. Is this probable? Is it more likely that it happened than didn't? And based on what we believe the probability to be, does the board wish to offer a consent order? And if so, on what terms and in what amount? think that's the,
So,
like a motion?
So we would like a motion, just what Chris said. Would you like for me to restate the motion, or are you okay with that? Make the motion.
I'll make a motion.
actually, if I may, I might recommend a motion and vote first as to whether the board wishes to offer a consent order at all. Need a yea or nay on that, and then once that vote has taken place, then a determination as to the number of alleged violations and the civil penalty or other disciplinary action the board wishes to offer in terms of a potential settlement. So let's take those separately.
Effect of a consent order.
One moment. The consent order is considered for board purposes a reportable disciplinary action. It will go on the Department of Commerce and Insurance and Regulatory Boards Division thereunder, both of those websites. And it is a public record available to anyone who requests it. And it may be considered by the board in any way the board deems appropriate if it's signed, executed, and completed as a factor if there are any potential future problems down the road with any of these entities. Think of it in terms of sentencing enhancement on the criminal side. The treatment will not be the same if someone on the criminal side has no prior record versus someone who does. And so that is the primary impact, as I understand it, of a potential consent order if signed and agreed to.
Oh, yeah, I'll make the motion that we consider consent order in this matter.
Is there a second? And seconded, motion's made and seconded, all in favor, roll call, sorry, Kim.
Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon, Steve Harb,
Aye.
Chip Hellman.
Aye.
It's unanimous, sir.
Now we will go to the motion we've already agreed for a consent order. What do we need to do next, Chris?
I believe the two issues outstanding would be the board's opinion as to the number of arguable violations, and then beyond that, the penalty, whether it's a civil penalty or otherwise, that the board wishes to assess and offer in settlement of these disputed allegations.
Is there some discussion about how a fine would suggest?
Fine available under the statute. That'd be my suggestion.
I would agree with that. I'm willing to make a motion that based on the recommendation of Mr. Whitaker,
Some multiplier on that, or is it just one single $1,000?
Let me get you a statutory side on that, Mr. Harb. There are two legal pieces at issue here. First is under the Tennessee Collection Service Act, TCA 6220-115, subsection B4, which says the board may assess discipline for violation of any provision of this chapter, being the Collection Service Act or other applicable law. Then also 6220-105A, that's the section that says no person shall operate a collection service license without, or collection service business without a license in the state of Tennessee. And as to the multiplier you requested, there is a provision under Title 56 which applies to which applies to insurance generally, and the Reg Boards Division is under the Department of Commerce and Insurance. Looking at 56, TCA 56-1-308A, says, with respect to any person required to be licensed, permitted, or authorized by any board, commission, or agency attached to the Division of Regulatory Boards, each respective board, commission, or agency may assess a civil penalty against the person in an amount not to exceed $1,000 for each separate violation of a statute, rule, or order pertaining to the board, commission, or agency. each day of continued violation constitutes a separate violation. What that means, in layman's terms, I believe, is if the board determines that the 7 instances of conduct that were discussed earlier are distinct and separate and individual and not so much part of an ongoing course of conduct, and it appears that the maximum fine that could be assessed via civil penalty would be $7,000. In the event the board believed that those contacts to be part of an ongoing course of conduct and violation, the board could potentially go higher than that. However, I would caution the board to be mindful of its past assessments of civil penalties in terms of amount, and certainly not to be excessive or go overboard. So with that, the board can discuss which of those two they believe to be the case, and then vote for a civil penalty as they believe appropriate.
Question.
Yes.
The 3 violations that are known, were they calls and callbacks? Or were they just discrete acts?
In attempting to be as fair as I possibly could, for example, if the initial contact was via email, then the response to that I counted as 1, if for no other reason than because the response was coming back from the debtor in question. So if the contacts were initiated or undertaken by the entities, and then that's kind of where I started counting. If it kind of to complete the cycle, if it's a phone call and call back, email back, something of that nature, I counted those as 1 because at least half of that equation is made up by the folks on the other end, not the applicants. I hope that clarifies it a little bit.
I agree with your assessment of that. The response by the debtor is not an incident on their part. I was more thinking of the time lag when there's a new call following up on the first call by Rialto. So that's a continuation of a time period.
Well, I think that's what this Title 56 says, is that I guess we could go from the first day a call was made and assume that each day after that they weren't licensed was a violation.
Yeah, but when did that stop? I'm not sure we could do that
Up
necessarily.
as soon as they get a
Yeah.
license. I think evidence or testimony to indicate that we have a gazillion dollar fine.
I would also offer, Chairman, that in the past, we've never considered a fine in that manner either. It's always been just a specific violation, and at that time, it's never been passion.
Mr. Trinkler, I'd also remind that each case is different, and the board may, if it determines the cases to be sufficiently different, may treat them differently. So that is the board's discretion.
We feel like that it would be only fair that we have a motion for a fine and and a consent order in the amount of $7,000.
That's the
Was that-
motion that
has that
I
already
think that's the
been made?
motion that I made.
Has that motion already been made?
You made the motion to just have a consent order. You didn't put an amount on it.
I thought I did say $7,000 in the second.
If that's the motion, then it's still on the floor.
Okay.
Motion's been made, and has there been a second?
Second.
And seconded that we have a consent order and a fine of $7,000. All in favor of that motion, please call the roll.
Art Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Aye.
Steve Harb,
Aye.
Chip Hellman.
Aye.
The vote was unanimous, sir.
Any other business come before the board? One note that I would like to to make to the board. Kimberly advised me that the legislature this year is going to start letting us know, the department know of any proposed legislation that goes on. I think we start up on the Hill on the 14th of this month, and she's going, because we meet every other month, she's going to send us an email and a link so we can follow it on the legislative website of any proposed legislation that would affect our.
That's good.
Any other business?
Move that we adjourn.
Motion
Second.
made, move to adjourn, and seconded. Thank you.
Roll call
right.
to adjourn.
Thank y'all very much.
We need a roll call to
Yeah.
adjourn? Okay, roll call to adjourn.
Bart Howard,
Aye.
Elizabeth Trinkler, Elizabeth Dixon, Steve Harb,
Aye.
Chip Hellman.
Aye.
The vote was unanimous to adjourn, Chairman.